In this video, you will watch arguments made by Advocate General of Punjab before the Honorable Supreme Court. This was the 7 judges bench, and why this 7 judges bench was made, what was the background of this case, that I have already discussed in the earlier video, the first video. This is the second part of this argument with relating to the case. So what was the background of the case was that the Punjab government issued a circular in which they gave reservation to Balmikis and Mazhabi Sikhs, that 50% reservation in SC was given to these classes. It was challenged in High Court. So High Court struck down that circular and lays down on the judgment of Chinaya judgment. In that case, the Chinaya judgment was decided by the 5 judges bench, and in which they have stated that state government has no power to give reservation. That means the subcategorize of SC. They cannot subcategorize the SC status again and give the quotas to another class. So that was done by the Chinaya judgment. Then it was referred to the 7 judges bench. Now you will watch arguments made by Advocate General. Then later on the other videos will come on the same topic also. So for that, please subscribe the channel and you will get notification whenever I upload the video on this topic or any other legal topic.
Lord, issue that your lordship should be deciding. In Punjab, my lord, we brought out an act in 2006 where out of the posts which were reserved for the scheduled castes, 50% of the posts were reserved for Balmikis and Mazhabis.
That was your first circular which you brought out.
Not this, yeah, no, this was not circular apart. This was the legislative act which was under challenge.
The circular preceded the
yes,
because the circular had been struck down actually
for
want of legislative sanction.
Right. So therefore, the legislation in 2006 and section 4, subsection 5, reserved 50% of the posts for Balmiki, Sikhs and Mazhabis, and there is a twofold implementation which saves it from the vice of discrimination and reverse reservation and reverse discrimination as we know it. This reservation in the 2006 Act was done on a twofold check and balance. One, that this reservation was limited to 50%, which in the development of law, Mullah, has become the Lakshman Rekha, which we are all advised not to cross. And the second check and balance was that this was implemented on a preferential basis. So, my lord, as I would say, this was not an act of exclusion by any standard. By any standard, what Chinaya, my lord, seeks to say is that this would be an act of exclusion. No. This was, if at all, an act of inclusion of those who were the most backward of the backward, to bring them, if not at par, at least up from where they stood.
Mr. Advocate General, when you said that it was implemented on a preferential basis.
That's right.
Can you elaborate that? How was it implemented on a preferential basis?
Lord, so suppose there are 10 vacancies for scheduled castes in a particular year or a particular recruitment. 5 were reserved for Balmikis and Mazhabis.
Right.
If they were available. And if they were not available, it was to go to SC others, which are Ramdasiyas and other scheduled castes, which were available. So in every recruitment, one would ensure that 10 scheduled castes definitely came in. But at the first instance, the right of preference of 5 of those 10 was to go to Balmikis and Mazhabis.
So there was no carry forward for...
carry forward was en bloc.
For the SC together?
Yes.
But not for the Balmikis and the Mazhabis Sikhs within the SC?
They were exhausted within that recruitment.
Yes.
So therefore, if I can put it in cost-effective way, this preference-based reservation was not at anybody's cost. It was not that if they did not get it, nobody would get it. If they did not reach the Mulot cutoff for getting that reservation, a scheduled caste only would get it. And your lordships are right, those scheduled caste vacancies were to be then, in common law Mulot, as we all know it, to be carried forward and not counted towards reservation, this, that, and the other. All those parameters were to follow. It was not that they would either be converted to general or not be filled up and left vacant. There's nothing of that sort. So therefore, that is the core, Bullet, that if you cannot even as much as give preference to somebody who's really needy, without that being at the cost of somebody, and that act of the state government is quashed, is that correct? We are here to urge that before your lordship. Now, Mulot,
Actually, Mr. Advocate General, there is an element of exclusion. I mean, let's not gloss over it. The point only is this, that because, the same exclusion which applies to reservation per se
of excluding merit, as we all put it.
Posts are reserved.
Yes.
Once posts are reserved for a backward community, A, there is necessarily an exclusion of the forward community in competing for those posts, right? Yet our constitutional jurisprudence permits it. Why? Because we treat equality as a substantive equality, not formal equality.
That's right.
Therefore, post N.M. Thomas, we have now developed jurisprudence to the effect that reservation is not really a breach of equality, but it's
in aid of equality.
But interestingly, the same argument which applies for reservation for the backward communities as a block, the backward versus forward, would also apply within the backward community, because what now we are really doing here by the measure which the Punjab legislature brought about was this, that within the reservation of seats for the scheduled caste, which is 15.5%, we'll take it for a moment, I mean, just as a benchmark.
That's right, as a ballpark.
Out of the 15.5%, which falls within the overall 50% cap, 50% of the 15.5% is reserved for the Mazhabi Sikhs and the Balmikis.
That's right.
Right? So, to that extent to which the reservation is exclusively carved out for them, the other backward castes cannot compete for those posts which are set apart from them. So, in a sense,
in the first instance, they can't.
In a sense, it is in that sense exclusionary. We can't gloss over the point that it is exclusionary.
We can't.
The only question really is this: can that exclusion not be justified on the same yardstick that we have applied for the exclusion in the backward versus forward context?
Mulot, if I had to put it very
because within the backward,
yes.
within the backward communities, within the scheduled castes, is there anything in constitutional jurisprudence which restrains the state from saying that I'm not deleting a community from the list of scheduled castes which has been designated by the President under Article 341 or 342, but within those communities, I am now making a classification that certain communities are more backward and therefore in greater need for protection on the same touchstone of substantive equality. And if that can be done by the state in reserving in carving out certain posts out of the competition of the general community, then why can't the state do it within the backward communities? That's really the
absolutely
point. But there is an element of exclusion, we must face it. I don't think we can gloss over.
What this entire example that your lordships have given in is based upon a very simple word, which is relative backwardness. Once we concede to the argument of relativity in backwardness, and it is the backwardness vis-a-vis the forward which brings them into the 50%, and it is the further more backwardness within the 50% which gives them the reservation within the reserve, then this argument has no problem.
Now, Chinnaiya's whole rationale was this, that the power to designate communities as scheduled castes and scheduled tribes exclusively belongs to the President and now therefore
Absolutely.
Parliament. For instance, in Milind, we
That's
have got
true.
all those Palghat Jilla Thandan, Milind Katwari, which came from Maharashtra.
That's true.
It is not open, for instance, for the court to say that though this community is designated as a scheduled caste, another community is part of the designated community. You have to take the list. That you can't do. Our court is that jurisprudence is now very, very well set.
That power has been